up, everyone? Welcome morning stream. I am listening to Nick Ricada's coverage of the Curtis Reeves trial, and I decided to do a painting as well. So today we are painting Marco's eye, and let me pull up a photo so I can do this. But hello, welcome. Good morning. I have linked Nick's stream in the chat, so if you guys want to watch that simultaneously, it's there. But I wanted to have something to listen to while I painted, so that way it makes this process go a little bit faster today.
The witness is the decedent's wife.
Now, Chad Olson did not turn his phone off. Now, here's what you're going to learn what was going on that phone. He was looking at Facebook. Social media. There was a website that he was looking at through Facebook. And he had been looking at.
Okay, well, you shouldn't be on your phone at the movies. So basically in this trial, a guy, I guess, shot some other guy for being on his phone.
Wait, the evidence is going to show that?
Tells Chad Olson to turn his phone off. Chad Olson doesn't turn his phone off right away. Now, he didn't turn his phone off. Chad Olson turned his phone off. Yes, but the evidence will show you that. Now, the evidence will also show you this. That
Where is the evidence going to show you that?
Asked me to turn his phone off and got up. Now, the way
nobody's claiming he shot him because he didn't turn his phone off fast enough.
The overall attitude and demeanor of the defendant, that's going to be described to you during the course of this trial, is very important. Because one of the charges the defendant's been charged with is a crime called murder in the and all of these laws are going to be explained to you at the conclusion of the case with judgment instructions. But a part of murder is that we have to prove that the defendant acted with ill will, hatred, spite, or evil intent. Ill will, animosity, spite, annoyance. So the defendant's demeanor and his actions will play into whether or not there was ill will, hatred, spite, or evil. So here's what's important.
Happy Valentine's Day, everyone. Okay.
The defendant gets up, and as he goes out the aisle, he's mumbling to himself. Now, you're going to hear from a witness who's going to tell you.
They keep saying a witness. It's the decedent's wife.
The evidence is going to show you that he was. He was annoyed that Chad Olson still had that phone light on. And he walks out, he's mumbling to himself. Now, as he's walking out fine. Meaning this, whenever anyone navigates through an aisle or a row in a movie theater, you necessarily have to move around people. It's kind of awkward. But he was able. There's a video that you're going to see that shows him getting up. People watch him leave the theater. Memories in the back row. Goes all the way down the steps. There might be 13 rows. You can see pictures. Walks all the way down the ramp, all the way to the manager's.
Can you guys hear that audio okay?
Now, when he's at the manager's, this is what happens. But when he's there,
hello, my name is Karen.
Watch his demeanor. Now, I don't mean to present to you, I'm not painting the picture to you that when he's at the manager's desk, he's banging on the desk and screaming and demanding action because he's not. But when we're talking about the demeanor of the defendant, the evidence will show you his ill will or spite. Watch his arms, watch his hands, watch his fingers, watch his facial expression.
Yeah, he's pissed because somebody's on their phone in the movie theater. I'd be pissed too. But that doesn't justify killing. Just saying.
Now, witnesses you're going to hear from are going to tell you this. They're going to tell you that the defendant did not appear to have any disability. He didn't have a cane, didn't have a walker, didn't have a wheelchair. The evidence will show you, and it sounds like a silly thing to measure, the defendant parked 133 yards away from the theater. Now, it sounds silly. Again, there's a football field and a third, but there's no handicap placards. The defendant's not handicapped. Wife didn't have a handicap placard. You're going to see video of the defendant as he purchases tickets. He's in the lobby area, in the concession area, walking to and from the theater. Now, why is that being brought up? Well, the evidence is going to show you this. We're going to talk more about it in just a little bit. But the defendant gives a taped statement to law enforcement. freely and voluntarily waives his rights. And there's going to be a picture of him during this tape statement. And one of the things you're going to learn in this tape statement is the defendant states he's got arthritis in his back and his knees. Well, the evidence will show you that, let's say that's all true. It's very, very bad. The evidence will show you that's no reason to shoot and go over the person. However, when you see the actual
the evidence
in the video, when you listen to the witnesses, guys, so he's.
That's a legal conclusion, by the way.
What
Again,
happens?
that's not an
When he walks
evidentiary
back
conclusion.
into the theater, after speaking to the manager.
Plus, Reeves' physical condition is relevant to self-defense.
Now,
Right.
It doesn't matter exactly when this happens. It's either as the defendant comes back into the theater, as he's sitting back down, or even some seconds after he's fully seated in his seat. Doesn't matter. But the defendant in this tape statement indicates that he reinitiates contact with Chad Olson. Now, what's the evidence we show you in this case? Chad Olson was talking to someone earlier, and it was the person in the row in front. At no time will the evidence show you that Chad Olson is volunteering to talk to the defendant. The defendant is the one initiating the conversation. And as the defendant comes back, based on his own statement, he indicates that he reinitiates contact.
There's contrary evidence.
And tells him this, and here's something that's important. Chad Olson did, in fact, turn off his cell phone. The phone was off when the defendant came back into the theater. The evidence will show you that the defendant could have just sat back down in his seat in the room and watched the movie, and everything would have been fine. The phone was off.
I hate this stupid argument.
Stand up and turn around.
The evidence will show you that after there's a conversation, Chad Olson is in his seat.
I mean, it's uncontested who was the initial physical aggressor.
Chad Olson is, I see you put your phone away. I told the manager for no reason. I submit the evidence will show you that there was no reason for that. Regardless, the statement was made. Based on the defendant's own statement, Chad Olson turns around in his seat. Now, when you listen to the defendant's tape statement, pay very close attention to the words he chooses to use and the order in which he uses these words.
Now the specific words matter.
The defendant states Chad Olson turns around in his seat, and now Chad Olson says some words. Now, in a perfect world, should that happen? No. The evidence will show you can't shoot someone. Chad Olson does turn around and starts to have some words with the defendant.
It's just not a compelling argument here. You keep saying, well, the defendant didn't have to do this. He could have done something different. But when the victim could have done something different, then it doesn't matter. You can't shoot somebody for that.
Right.
Chad Olson stands up and continues, and he looks at the defendant. Chad Olson's in his row. Remember, he's an entire seat in front of the defendant.
An entire seat,
He's an
6
entire
inches.
row in front of the defendant. An entire seat.
He's literally
And
the
during
seat
this
in front
conversation,
of him
while he's
and to the
standing up,
right.
he says, if it's any of your business, and there may be an F-bomb in there. I was texting my daughter. Now, the evidence will show you that he was on Facebook. The evidence will show you that under the law, whether he was on Zillow, buying a car, buying a house, checking the stock market.
You can buy Zillow on your, or you can buy cars on Zillow. I didn't
I
know.
submit the evidence will show you he was just trying to get the defendant to leave him alone, and that's what he chose to say. Really doesn't matter.
Can you imagine dying
Well,
over
the
something
defense
this
should chew up
stupid?
this opening statement.
And as he's standing up facing the defendant, you will see this on video. Chad Olson reaches over with his right hand. And he reaches over into the defendant's lap and he grabs something. Now, this might sound silly.
With his penis.
Because he grabbed a deadly weapon out of the defendant's lap.
Why would he do that?
Yeah, this will show you absolutely not.
Does he grab a pumpkin?
Grab a big tub of heavy popcorn. No, here's what you're going to learn during the
Heavy
Chad Olson
popcorn.
reached over with his right hand into the lap area of the defendant and grabbed a bag of popcorn.
I'm kind of on the side of the defendant after hearing that.
Now, the evidence will show you, of course, in a perfect world, should Chad Olson have grabbed a bag of popcorn and tossed it on the defendant?
Well, that's a battery.
Of course not.
I mean,
The
it's a
evidence will show
crime.
you can't shoot and kill another person.
Well, maybe.
So the evidence
It's
will
a
show you
battery
there's
on someone
a
over the
couple
age of
things
65
happening
years
simultaneously at
old,
this point.
which is a
So I want to
felony
break
in
it down
Florida.
just a little bit.
And you can shoot somebody in
Chad
Florida
Olson
to prevent
stands
a
up,
forcible
he's
felony.
facing the defendant. says something about texting his daughter. He reaches over, grabs a bag of popcorn, and flicks it. Doesn't pull it back, he isn't using it like a bat, just flicks the popcorn. His hand is now coming back. At about that very same time, Nicole Olson, remember, she's sitting in front of the defendant.
A whole
She's
row.
starting to reach over with her left hand while this is happening. And in the process of getting up to say, honey, it's just sit down. So her hand's up.
So he's standing
When her
up
hand
now.
is up,
Yeah.
and while Chad Olson's hand's coming back from that popcorn toss, this defendant.
Morning, everyone. Welcome. Please smash the like button if you haven't already.
To kind of go over what happened. The evidence will show you
I'm listening to Nick's coverage of this trial. If you guys are wondering what I have open behind me.
says a few words. The defendant reaches in, grabs the popcorn, flicks it. Now, this is important to watch in the video because it goes back to arthritis, my back, my knees. What you're going to see on the video is the defendant in an incredibly quick and swift maneuver reaches his right leg out as he's leaning back, goes into his pocket to get his firearm that he's brought into the theater, pulls it out, and lunges forward to shoot Chad Olson. The evidence will show you he's not back in here, but watch the manner in which he grabs his firearm, how quickly he is able to do it, how fluid he's able to do it, and how he lunges forward as he shoots. And why is that important? Well, let's go back to the instruction of Bill Will Agent Spider. The evidence will show you he was mad. Chad didn't listen to him, and Chad broke popcorn.
That's not ill will, spite, hatred, or
So,
intent,
what happens
actually.
next?
None of those apply to him
After that,
being mad that someone threw popcorn at him.
Chad stumbles. He begins to turn to go towards the aisle. He goes down a couple of seats. He's shot in the chest. He can't make it to the aisle even. He falls down at other people in the theater. Nicole Olson's finger is almost shot off. It's almost severed from the bullet going through. She's screaming. Chad falls on the ground. There happen to be nurses and other people there that try to help Chad Olson as he's laying on the ground with that bullet in his chest. Now, ultimately, of course, Chad Olson dies. He's basically dead.
A little 380 caliber round. 380s
There
kill a lot
happened
of
to be an
people.
off-duty deputy, not from the Pasco Sheriff's Office, but from another county in the theater. He gets up, you're going to see this on video, and he walks over to the defendant. The defendant has his gun on his lap. It's taken from him. The gun eventually is given to a sergeant at the Pasco Sheriff's Office. That gun is eventually sent to a place called the Florida Department of Law Enforcement. Now, during this trial, there's going to be some stipulations. Stipulations are agreed upon facts, so to speak. You get these, there's not going to be any other testimony on the matter. Basically, just accept it. Now, one of the stipulations you're going to learn is that this firearm, the one the defendant used, is a 380, was sent to the Florida Department of Law Enforcement. There's a shell casing there. Shell casing gave that testimony. Now, that's not an issue in this case, because this is not a whodunit case. The important part of that stipulation is that this firearm, the one the defendant brought into the theater,
Alrighty, I think I'm ready.
It malfunctioned, wasn't an accidental shooting. This was an intentional and purposeful shooting. The gun was working fine.
Not going with the edge comb self-defense theory.
People are working on Chad Olson, his other deputies with the defendant.
Not yet.
You can imagine when there's a 911 call about a shooting in a movie theater, there's a fairly large law enforcement response, and there was. And this is when the investigation begins. Now, people go in the theater, they go to different parts of the theater. Some are in front of the screen, some are in the concession area, the lobby.
That would suck. You just go to a movie and then you get stuck doing a trial because somebody shot someone.
Wait for the movie theater to be secured before they can go in to try to help.
That's always true.
When the deputies came in, they made sure the scene was secure. They were trying to help Chad, dealt with the defendant. The rescue comes in, and everyone goes to the hospital. Congratulations, you're saved. Eventually, Nicole has now, while deputies are there and people are in different parts of the theater, they hand out these blank forms, and sometimes they're called written statements. And people are not given any instructions on how to fill these out. They're just told to write down what you know. Now, of course, these are people in the theater who aren't law enforcement officers or lawyers, and they don't know how much to write or how little to write. Some people write one sentence, some write 10 sentences. It's basically just what they saw. Some people are going to tell you they were themselves. And law enforcement used this as a first step in their investigation. Read those written statements, trying to figure out who they needed to talk to in some type of order. Who they were going to talk to that day, who they were going to follow over there. That's what happened with the written statements. Now, when people filled out these written statements, some people were near them, but no one was telling other people what to write or what to say. The witnesses that come into court are going to tell you what they personally heard and what they personally saw. That's it. Now, witnesses were interviewed. The defendant himself gave a statement, as I mentioned. He gave a tape statement. What the evidence will show you is that Chad Olson was shot and killed over tossing copper. The defendant's statements are fairly consistent with other testimony and other evidence, including the video, up until the point of time of the shooting. The evidence will show you that the defendant's statement is not accurate as well, what had occurred, based on what you're reviewing in the course of this trial. So what did the defendant tell the police? The defendant tells the police that he went to the theater. Obviously, he did. While he was in the theater, he saw Chad Olson had his phone on. Now, the defendant states he came forward and was being nice, asking him to turn the phone on. When Chad Olson did not, he got up and went to tell the manager. He came back. The defendant says that when he came back, he did talk to Chad Olson. And he told him the statement that I represented before. I see you not on your phone anymore. I went to tell the manager. He says, and again, the words he chooses are very important. You're going to learn that he was former law enforcement, so he knows the importance of the accuracy of words. He says that Chad turns around in his seat. At that time, there's some words between them. And that indicates that
J-Bam, thank you, Shabbat. I know you got the fans back, and we support you, Anna. Oh, thank you. I appreciate that. I have a feeling that's reference to a certain stream I did recently.
It seems as though the evidence will show you that the defendant states nothing at all about the popcorn in the beginning. Is that event never took place?
It seems as if.
Now you're going to learn with your glasses on the transcript 2020 vision.
Oh, you can still miss things to 2020.
What the defendant states is that Chad Olson is coming over on top of him. Okay, so when you listen to the tape statement, at first it appears as though the whole popcorn thing never happened. Later in the tape statement, the defendant states when Chad Olson jumped up, the popcorn fell almost immediately. Well, the evidence is going to show you that after the popcorn fell, that's when this defendant immediately took out his firearm and killed Chad Olson. So the evidence will show you that tape statement is not exactly true. He says that when Chad Olson jumps up, the popcorn fell immediately. And this is the picture painted in the defendant's tape statement. Here's what the evidence will show.
So he didn't perceive the popcorn being thrown at him. He perceived the man attacking him. Is kind of how it sounds.
Yeah.
One row down, one seat over. He's back in his seat, and he's got his left hand up.
Reeves also claims that he was actually struck in the head with some hard object. Maybe Olson's phone. He had a red mark on the side of his head when he was photographed by police.
Is virtually on top of him. In his lap. Those are the words the defendant himself uses. Virtually on top of him, in his lap, and he's got his left arm out, and he's touching his arm or his shoulder, but he really believes he's touching Chad Olson's chest because he's so far into him, into his row. And at that time, he has to straighten his right leg out, pull out that firearm. The defendant states he's surprised he didn't shoot his left hand because his left hand was so far out when he took that shot. He's surprised.
Okay, this isn't actually helping the prosecution's case, to me.
There'll be no witnesses that will come in here and tell you that happened. No one heard any yelling, screaming.
I think the defense has evidence of stippling on the left hand, which would put it in front of the muzzle of the gun.
You're going to hear about a term called stippling during the course of this trial.
There it is.
Stippling, and this might be a really bad description of it, is when a firearm is fired, material comes out, hot material, and anything that's close in its way. It's these embers, so to speak, and there's a burn mark on the skin. Now, you will see stippling in this case. The evidence will show you there was stippling on Nicole Olson's hand because it was in front of the firearm when her finger was almost shot off. You're going to see stippling on Chad Olson's wrist because when he brought his.
I hope they reattached her finger.
Popcorn,
I mean, she already lost her husband. She doesn't need to lose a finger, too.
but the evidence is going to show you there's no stippling on his left hand.
Oh, maybe I was wrong.
His left hand was not out. No. You got to get off me. That's what the evidence is going to show you. Now, after the defendant fires the shot, there's some important words that people in the theater hear. And these are people that don't know each other, and these are people that are in different areas of the theater. And the defendant states some words to the effect of throw popcorn at me or throw popcorn on my face. Yet when you listen to the defendant's tape statement, it never really brings up. The evidence will show you that's important for ill will and spite. And when you see the way he lunges forward with the firearm and makes that statement, you get a clearer picture of what was really going on in the theater on January 13th.
I watched the video. I didn't really see a lunge forward.
The defendant states in this
Maybe
tape,
I missed
I didn't know there was a video.
his arm out, yelling,
Need to watch that.
That's why they have this enhanced video version, so they can do the Binger thing. See, it's right there. It's right there. You can see it. There'll be some vague movements.
We're going to hear defendant or law enforcement. Words and choices of words are important. The defendant states in this tape statement that he's hit on the left side of his face. Well, witnesses are going to tell you they never saw that. And the evidence will show you that.
I never saw it either. That doesn't mean it didn't happen.
It's not possible. The evidence will show you that Chad Olson was a row in front and a seat over to the right. And that it would be virtually impossible for him to do this hook. That hook all the way around from that distance, across an aisle, all the way across seats, that struck the left side of the defendant.
Isn't Chad Olson tall?
Yeah, 6'3".
I mean, I could easily hit someone in the...
The evidence will show you there was no injury.
This guy can't.
As if he was struck that hard. The defendant, in his tape statement, you will learn, says he was dazed. He wears glasses. You'll see there is no injuries, many markings for glasses. So he hit that hard, but he felt he had a kill. At some point in the tape statement, the defendant indicates he thinks that maybe a cell phone was at play because he saw the blur of the screen. Now, you will learn that a cell phone was found in front of the defendant, and it was in fact Chad Olson's cell phone. I submit the evidence will show you that it got there in one of two ways. One, because he was holding it in his left hand or his left side.
How do you put it away?
We know that because that was the side that was bothering the defendant. And when he stood up and he grabbed that popcorn, it fell over. Or at the time he was shot, it was dropped. But the evidence will show you that no witnesses see anything.
Well, if he dropped it when he was shot, then he was leaning over the row, right? He was leaning.
Yeah.
Over,
the fact that that cell phone exists in the row is consistent with his statement.
Cell phone was
not
also sent to the Florida Department of Law Enforcement. And there was some DNA testing done on this phone. Chad Olson's DNA was on the phone, but not the defendant's. Now, you're going to see pictures. The defendant did have some redness on his left eyelid. Possibly the most fragile part of the human body. The evidence will show you he had his glasses on. And his left eyelid, only his left eyelid, was after the shooting, he was rubbing his face and rubbing his eyes. He indicates he thinks there's something in his left eye. Paramedics check him out. There's nothing in there. They do a saline rinse test. The defendant indicates in his tape statement that he second-guessed himself. He's sitting in the cruiser, and you're going to hear he says, second-guessing himself. Did he hit me?
He's an old man.
This is the picture that's going to be painted for you during the course of this trial. The defendant also states, and I apologize for cursing at some point in this tape statement, and again, I apologize for the language, but we're shit this. Now, for his actions, the defendant's been charged with 2 crimes. Murder in the second degree and aggravated battery. Now again, all of the jury instructions are going to be explained to you at the conclusion of the case. Now, suffice to say, this is what murder in the second degree is. What we have to prove to you is Chad Olson is dead. It was due to the criminal act of the defendant, and it was by an act that was imminently dangerous to another, demonstrating a grave. And shooting someone at close range is an act imminently dangerous to another. That's not going to be an issue in this case. And you do it with a depraved mind. That's where we fall back on the definitions that you're going to learn: ill will, hatred, spite, evil intent. The other crime that the defendant's been charged with is aggravated battery. Now, going back to murder in the second degree, we do not have to prove to you that the defendant here intended to kill Chad Olson, just that he intended to act, which he did. This is not a case where it's an accidental shooting. He did intend to shoot him. We just don't have to prove he intended to cause Chad Olson's death. Now, aggravated battery, what we have to prove to you is that the defendant did intentionally, knowingly, and unlawfully touch or strike Nicole Olson against her will. Now, obviously, he didn't do that with his hands. He did that by using a gun and firing a bullet. So it's the same analogy. Did he touch or strike her against her will? And did he use a deadly weapon? Yes, a firearm is a deadly weapon.
You don't say.
The other way that we can prove aggravated battery on Nicole Olson is did he intentionally touch or strike her against her will? Yes, and cause great bodily harm, permanent disfigurement, or permanent disability. And the answer is yes. You're also going to learn about an instruction called transferred intent. And basically what that means is if one person intended to do an act, meaning the defendant intended to do an act to one person, but ended up harming another. In other words,
you don't get to make a defense saying, well, I didn't try to hit them.
He transferred intent. And that's how we get to the aggravated battery charge. Now, what is this?
Well, it presumes unjustified intent. If the intent was justified, that transfers too.
Right.
It's apparent the defendant is claiming self-defense. So you're going to hear a lot about self-defense. At the conclusion of the case, you're going to get all of the self-defense jury instructions.
Maybe not all of them.
The question would be not whether or not this
maybe not provocation.
No evidence of that. It was an intentional shooting. Whether or not the defendant was lawful, whether or not he was justified in using that deadly force in killing Chad Olson. Now, this is basically what the self-defense instruction indicates. The use of deadly force is justifiable if Curtis reads reasonably, and these are the important words here.
Guys, haven't already, please smash the like button.
That the force was necessary to prevent imminent death. He was going to die or suffer great bodily harm, while resisting an attempt to commit felony crime. In deciding whether or not the defendant was justified in the use of force, the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used.
No mention of the forcible felony
And this will show you
basis for deadly defensive
at the
force.
time
You
that
kinda
the force
glossed
used
it.
the shooting took place was that another individual had tossed powder. The danger facing the defendant need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person, under those same circumstances, would have believed that the
Which means,
danger,
as a
and the evidence
71-year-old man,
was just grown up in, could be avoided only through the use of that force.
so again,
So the question for you
not to
would be
defend the
this.
guy, but his
Would a reasonably
perception,
cautious
is it
and
reasonable
prudent
for him to
person
think that a
at 71
young
years old
6'3" man standing up, turning
would a
around,
reasonably cautious
grabbing at his popcorn is taking a swing at him and puts him in danger of serious bodily injury? Is that reasonable? If it is, then it's justified.
who's able to walk all around the movie theater, who has over 20 years of law enforcement experience, including 15 years on the Special Weapons and Tactics Squad, also known as SWAT. Sitting inside a theater that, by all accounts,
Back when it was a cavalry unit.
The environment on pitch black, not definitely black. Reasonably believe that the danger would only have been avoided through the use of shooting shadows. The answer is going to be absolutely not. The evidence will show you there were some differences between Chad Olson and this defendant on January 13th.
Guy doesn't look 270.
Chad Olson was 6'4", defendant here is just 6'2". 2 inches difference.
6'2".
Outweighed Chad by 65 pounds, but there was an age difference. The defendant was sitting an entire row back, an entire seat over. But the most important difference we learned about during the course of this trial is that one of those 2 individuals brought a loaded firearm into a theater which shot and killed another person after popcorn was tossed on them.
I would hammer on that entire thing. I would really point out how much this guy is misrepresenting.
He's really being deliberately deceptive on so many fronts. I mean, the defendant's not claiming that he shot somebody because they had an exchange of words.
That you're going to see here during the course of this trial is going to tell you that that is the lawful and just verdict in this case.
Thank you, Mr. Rosenwasser. Ladies and gentlemen, who's going to... Okay, we're going to take a break, yes. Mr. Michaels will be doing his opening statement in a few moments, but I think it's appropriate
Dino
to
Michaels,
take a 10-minute recess.
bow tie.
So,
he's got a bow
remember
tie.
my instructions during the
Immediately
recess.
distrust him.
No research, no discussing the facts, etc. And the bailiff will, where are they going to go to the jury pool room or just mill about and then return back here? Okay. All right. So as usual, you can mill about a little bit and then, but try to stay to this side of the courthouse if you would, and head back.
So the defendant still hasn't bought himself a decent suit jacket.
Deputy Martin will come and get you. Any questions?
He's only had 8 years to shop. All right, I'll pull their feet off while we wait. So yeah, so that's the prosecution's case here. Now to the chat, I want to say something about my personal perceptions and biases the way they are now. I go into this thinking guilty. That's where I am on this, because to me, just the basic description or synopsis of the situation, absent any arguments, absent any witnesses or whatever, is that I have a hard time believing that a guy shoots somebody over popcorn and it's justified, because that's kind of the narrative of the case, right? But now, as we're sitting here and as we listen to the prosecution's opening argument, I'm starting to have my doubts. And the reasons I'm having my doubts are because I'm immediately starting to distrust the prosecution's description of events. Because and it starts with that row, an entire row in front of them, an entire seat over. It's literally right there. I mean, you've all sat in a movie theater. And it had to be. It's
uncomfortably close, right? I mean, we don't enjoy that part of it. I mean, the prosecution's trying to make it sound like there was an empty row between them.
And this guy is 6'2", which means his knees...
He's 6'4", actually.
Well, the big guy, the dead guy is 6'4", but the defendant's 6'2". Right. So the defendant's knees are likely against that seat or very close. Just take it from a guy who is 6'2". You sit down at basically any movie theater in the world, your legs are right up next to, if not pressing into the seats in front of you. They just are.
I'm glad I'm not tall.
So,
get plenty of leg room.
So like the idea that he's way back or whatever from this guy is probably not true. In fact, he's likely hunched forward a little bit. But that being said, it's right there. There's no, and we know it has to be right there because by the prosecution's own statement, this guy stands up and grabs popcorn from his lap, which I didn't know. I thought he grabbed it out of his hand. But he's reaching in so far into his face that he's grabbing the popcorn out of his lap and then flicking it at him, just loving a love flick or whatever of popcorn. So now, based on the way that the prosecution has presented his case, this is just me, I'm starting to distrust the factual representations made by the prosecutor in the opening statement, because I've been to a movie theater before, and I know that now his definition doesn't sound accurate. And this is why it's really important not to oversell these things, in my opinion. Because if you get me in that jury box, I'm a guy going, wait a minute, I don't like any of this that you're saying. this doesn't ring true to me. This sounds like you're misrepresenting stuff.
Yep.
Also, I agree with what you're saying. The witness that he keeps mentioning is the wife. And I think that omitting that fact is maybe setting the jury up to be very disappointed when they find out the witness who's saying this is the wife and not someone else. But what are your impressions of that opening statement so far?
Yeah, I thought it was at best ambiguous, at worst deliberately deceptive in characterizing the events. And if you're the prosecution and you think you have a conviction here, you don't need to do that. And you set yourself up for failure. I mean, this is an adversarial process. The defense gets a chance to talk to the jury now too. And if the defense is smart, they will highlight these mischaracterizations, these acts at deception. The state keeps saying an entire row. That was 6 inches away. Why are they doing that? Why are they trying to create a misperception, a misunderstanding in your minds? Ask yourself that.
Right. And one of the other things that's really important to remember in any self-defense case is it is the defendant's perception of reality, so long as that perception is reasonable. So it doesn't actually matter if the guy grabbed his popcorn. If the motion to grab the popcorn looks, for all the world to Curtis Reeves, like that guy is trying to hit him and cause him harm, and this, again, like I know he's 65 pounds, he's still 6'4". I don't want to be hit by any 6'4" man. I don't care if he's thin and wiry or gangly or whatever.
That's a big
There's a
dude.
lot of bone mass there that can transfer energy.
Almost
even
half his age, too.
Right, even if there's very little muscle, but 6'4" guy, and he even characterized it as jumps up. So he jumps up out of his seat, turns around, and goes to grab the popcorn. If the jury agrees with Curtis Reeves that he is perceiving a threat in that action, then he very well could be justified, even if the reality of events turns out different than he anticipated them to be. Now, there would be a question as to how much time elapses between this motion and the shot, but like the prosecutor's making the case that the shot happens immediately after the popcorn is thrown. Well, and he's talking about like how fast that reaction is. Maybe it wasn't fast. There's a very real possibility that reaction was slow, and that he's reacting to the movement that comes at
Fox
him
Mulder.
when the guy's
I love
grabbing the
X-Files.
popcorn. I don't know, but that's not unreasonable to think of, in my opinion. Now, will we get testimony to that fact? I would. If I'm the defense attorney, that's what I'm trying to elicit out of my client, is that he was not reacting to the popcorn. He's reacting to the 6'4" man's arm swinging at him, and the fact that he got his gun out at the time that fast, even at his age, is still impressive. But that he was reacting to being attacked, not reacting to having popcorn thrown at him. And so I think it'll be the defense's job on their opening statement to really poke as many holes in the narrative that they can, and point out anything where the prosecution has even a hint of deception, because the argument should be, this is a straightforward case, and if the state had a straightforward murder case, they would present it straightforward, but they're not. They're not telling you this. They're not telling you that. They're trying to convince you so hard of something here, and the question is why. We think this is a straightforward case, and we're going to tell you this is what happened. There was a discussion about a cell phone. When our client came back from the manager, he sat down and said, "Guess I didn't need to tell you about that, or didn't need to talk to the manager after all. I see you put your phone away." And then after that, the other guy turned aggressive. And the other guy got up and turned around. And he grabbed my client's popcorn out of his lap, yes, and he threw popcorn at him. But really, what was that throw? What was going on there? That was an assault on my client. My client perceived it as an assault from a larger, much younger man, and he turned and he had to fire. That was the only way he could do this. It's a very straightforward case of self-defense. Look, when you're my client's age, any little thing can happen and cause you a permanent injury or even death. You've all heard of someone falling and breaking their hip. You've all heard of how quickly an older person's health can decline from the slightest injury. My client's thinking about that every day. He's watching his own health decline. He's watching his wife's health decline in real time. It's preeminent in his mind. And this guy put their entire lives together in jeopardy. And that's the narrative you build, in my opinion. I mean,
yeah, there's no question who was the initial physical aggressor here, right? That was Chad Olson. Maybe by the strike to the head, maybe by just grabbing the popcorn and throwing
Could
it
you imagine
back.
getting into a fight
But
with like a
this is the trouble
70-year-old
with the,
man at a movie theater?
Frankly,
Like, how disrespectful.
during the self-defense immunity hearing was actually better from a substantive legal perspective than this. They, at least there in the self-defense immunity
It's a
hearing, the
problem
other
with being a
attorney,
girl and
I
having a
think
bunch
it's,
of hair and you get
Prosecutor
hairs
Martin.
on the canvas.
I don't know who this guy's name is, by the way. The reporting on this case is terrible. I keep trying to find out the names of the prosecution team, and the newspapers never even mention their names. But at least they touched on each of the elements. They touched on innocence, the issue of provocation, which we heard argued earlier. They touched on imminence, that even if there was a threat, the threat was over by the time the shot was fired. They seem to be backtracking on that now by saying how quickly it was that the shot was fired. They talked about proportionality, that even if some defensive force would have been justified, deadly defensive force would not have been justified. It was just popcorn. They talked about, well, not avoidance, of course, because Florida is a stand your ground state, so there is no legal duty to retreat. And frankly, in this circumstance, even if it were a duty to retreat state, you only have that duty if safe retreat as possible in the confines of a movie theater row. That would seem unlikely. And then they
being
touched,
that old.
yeah.
I mean,
Hard
even
for
if you
anyone.
can navigate a row just fine, navigating a row while retreating and running is a whole different story. Plus
While
the
you're under
places
attack,
there.
right? Because that's when the avoidance issue matters for legal purposes. It's when you're making the decision to use defensive force. Not 5 minutes later you could have moved seats in the theater. That's not what avoidance means in the use of force context. And then, of course, reasonableness. That even if he had a subjective belief in the need to act in self-defense, that belief was not objectively reasonable. They really touched on all of those in the self-defense immunity hearing, and I didn't really hear that here. But maybe I was distracted by the repetitive entire row over and over and over again.
Yeah, that just was. I just didn't. It's not necessary to do that, and that's what I dislike. And the state, you expect that from a defense attorney, right? You expect the defense attorney when they're grasping for any straw they can find
to raise that reasonable doubt.
Right. We're going to try and just plant some little seed in the jury's mind that they can grab onto and hope that they do. The state, in my opinion, is always held to a higher standard and a higher duty because they're the one trying to take away liberty or life. Like they're the one who is trying to put someone in prison forever. And so they need to be the most honest. They need to be the most factual based. And remember, when they're bringing these charges, they have to have probable cause to believe that the charges are correct and that they can prove that guilt beyond a reasonable doubt at the time they bring them. So when they do that, when they say that, or when they bring the charge and they're bringing this to court, they're making a representation that by the actual facts, not by the things the jury might be able to pick up on. And that's a key distinction between the prosecution's duty and the defense's duty. And that actually really bothered me about the argument over provocation at the beginning. Is if they're going to argue that the words or that the actions of Curtis Reeves are provocation when Florida law clearly says that it must be a physical act and that mere words are not enough, then but we hope that the jury misunderstands that and finds provocation. Again, it's looking deceptive to me, and I hate that. It's the state's job is not to do that.
Yeah, I mean they're trying to get a conviction by hoping they can deceive the jury on what the law is and how the facts fit into that law, and that's not justice.
No, the facts that what they should focus on is because they have the crazy thing is the state actually at first blush has a pretty good set of facts. He's not hit as far as we can tell. He might have been hit by a cell phone or something. Don't know. But he's not obviously hit. The guy's not grabbing him and throttling him or anything like that. he gets popcorn thrown at him, and he pulls a gun out and shoots him. Shoots the guy's wife. But shooting the guy's wife's hand isn't actually good. If the wife felt the need to hold her husband back, and if I'm the defense, I'm going to bring that up. The state's charging my client with battery of the wife because she shot her hand. Shot her hand because her hand was holding her husband back. Even she's afraid of what her husband's going to do to this old man.
That's right.
So, I don't know. We'll have to see how it goes. I'm anxious.
And of course, the state has to disprove self-defense beyond a reasonable doubt, folks. The defense just has to maintain a reasonable doubt that this could have been self-defense, and it's supposed to be an acquittal. The defense doesn't have to prove it's more likely than not self-defense.
Yeah. Okay. Squeeze Louise says, I don't understand the point of this trial. The dude was playing on his phone in the middle of a movie in a dark theater. Are we really going to pretend he didn't deserve it?
Well, you can see the prosecution is concerned about that perception of the events, right? Because it wasn't actually a dark theater yet, and the movie wasn't actually playing yet. But the prosecution clearly believes that if the jury were to believe those to be facts, it would be an acquittal every day of the week.
Yeah, and well, when you think about it, there was white light from the cell phone. When someone, an entire row in front of you and an entire seat over, opens their cell phone while the previews are on, it looks like the frigging sun has just risen over Hiroshima or whatever. Like, oh my gosh, you can't. It's very, very bright. It's not like a little thing. It drives me
I
crazy.
fucking hate it when people are on their
Usually,
phones at the theater. I get so mad.
Because it's not during the movie yet, right? But when it happens, it is horrendously annoying.
And clearly the theater thought it was past the point at which the phone should be off because they put that notification up on the screen.
Right. And the interesting thing to me is how they're already framing his statements to the dead guy, right? Like they're framing him by the wife's testimony about how he sounded, which is going to come out. He sounded very mean or whatever. But, up on the screen is a thing, put your cell phones away, and the guy's got his phone out blazing into the background. The guy's like, hey, can you put your phone away? Could have been it. Like he leans forward into almost virtually into his personal space. If he leans forward and just says, hey, can you put your phone away? That's not actually menacing. That, it might be, I don't know if that's a good idea or a bad idea. I don't usually do stuff like that because I don't want to get shot or hit or anything like that. But
I'll yell across a movie theater if somebody's on their phone. I'll yell at them. I'll be like, get off your phone.
Thing that he did, he leaned into his personal space.
I did it during the Spider-Man movie. I was so pissed. Somebody turned on their fucking phone.
He was texting the babysitter. No, he was not actually. That is untrue. That is an untrue statement. That was what he said he was doing. That is not what he was doing. As the evidence will show, according to the prosecution, that is not what he was doing. He was looking at a website that he went to from Facebook. And I hope everybody caught that. The prosecution is very hesitant to talk about what he was doing. I don't know. Is it confirmed what website he was on?
Yeah, they know what it was because
the gambling
they did the
website?
forensics on that. That's how the defense characterized it earlier. And of course, you.
I'm bringing it back up.
Sure.
I think this is going to look really pretty when it's done.
The judge has a very sentimental cup on the bench there. I guess her wife got it for her.
Is that real? Are you serious?
Yeah, it says you and me.
Oh.
It's off screen now, but when they pan back to the right.
Yeah, I saw it for a second.
I'd like for the court to read it. I think it's proper coming from the court before I discuss it. May I approach?
Yeah.
Bad Vibe says this prosecutor is creating empathy for the defendant. No juror wants to be sitting in the defendant's seat against this gluttonous sombrero. They've got to learn how to manage a microphone in a courtroom.
Here it is, 2.3 stipulations. When lawyers agree that certain facts are true, that is called a stipulation. stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact, or at the moment, well, right now,
There it was.
Oh no!
Someone's got old time
sorry,
rock and roll
that
for
my
a
husband
song.
uses from me. Gets my attention.
husband, she said.
Okay,
It's good to
so
know.
I'm going to read that instruction, then I'll read the statement.
He must be the one who cuts her hair.
Mm-hmm.
Aw. That was mean.
Look at the demeanor of these guys. Are these two defense attorneys brothers? They're the aerodynamic crew. Oh my goodness. Delhi 8079 says, even if he theoretically could be legally justified, I don't see a jury ever deciding he was justified to shoot him. And I think it's a hard sell. It's a hard sell, but it's not impossible. And we'll have to see. The prosecution can lose this case by their conduct too. Remember, all of these people live under the state. And if the state lies enough to the jury or misrepresents enough to the jury, they can just say, you know what, F you guys, because you could do this to me. And that is something that people occasionally consider. Gates of Above says this trial finally started after 3 presidents in office. Will we get another before the trial ends?
Oh my god, really?
It would be really horrible in so many ways if the defendant died during the trial. You wait all this time, do all this prep, and then he just kicks off, and it's over.
They come back with a guilty verdict, and he gives the jury the finger and bites that cyanide capsule in the back seat. You ain't getting me.
Caligula says, nah, Matt Smith was right in Doctor Who. Bow ties are cool. I don't like bow ties, man. Very rare.
Yeah, I mean, this may well be a trial, but it's less a case of the defense winning it than it is of the state losing it.
Yeah. Gates of Above says, yes, I don't like how the prosecution started is suspect, but at the same time, one of the defense attorneys has a bow tie, so who do I side with? The bow tie is a heavy distrust. I agree, 100%. I'm with this argument. I do not like, why are you wearing a bow tie? I don't trust you. Elena Stansby says, this case is crazy as hell. Love the UK, Great Britain. P.S. Thanks, Andrew, for the statutory law.
That was yesterday's show.
Oh, okay, cool.
Look at the length of that tie on the prosecution. Wait till the defense lawyer. It's almost touching the floor.
The guy with no chin, that
The
one?
guy with no chin, yeah.
Aw.
Gosh, I want that. Now I need the defense to move. I need to see how long this time.
I mean, he's going to trip on that.
Holy!
Honestly.
That thing keeps going.
Oh my god. It is a
It's
long
almost a
time.
cod piece at that point.
I like to cover up with the tie just in case my pants fall down. Happens very often.
Well, let my fly down one case, and these are embarrassing.
I always love I love looking at people who are standing around and like have forgotten that they're on camera. Like just look at how their postures and their demeanors. It's interesting to me how people stand, because if you know you're on camera, like you never want to stand like the taller prosecutor is standing right now. Like his hands are turned out. He's got kind of an awkward sort of like lean going on. It's weird. It doesn't look natural. It doesn't matter at all, by the way. This is not like legal strategy talk here. It's me observing people on cameras when they're doing something more important and don't remember they're on camera. It's the difference between reality and TV shows also. Like, look at how happy this guy looks. Like, this guy looks really happy. I don't get it.
He did look very happy.
It's
Oh,
just
good
sitting
Lord.
there like
That
a
was
smile.
creepy.
I like watching this trial, man. Like, why? Who are you? Why are you there? You're up in the front row. You're clearly with somebody.
Oh, Peaches
Not a
woke
good
up.
situation for anyone who's present.
I hear him.
That was on the TV screen in the courtroom. It must be one of the experts who prepared the video.
Oh,
It was Spectech LLC.
Neil Peart says, "Damn it, Nick! I feel called out, lol. I stand with a lean ever since I took a chisel to the knee." No, it's not. It's not the lean. It's just the way. It's the way the guy is presenting himself. Okay, so they're previewing the video that they're going to show during their opening statement to see if the prosecution wants to object during the opening statement. Probably. Just clear that up. Because you don't want to get interrupted if you don't have to. Excuse me. Saint Chef says, "I have a friend that has the worst luck in theaters. Complained about a couple and got into a fist fight. Complained about a lady on her phone and got called a binger. Got free tickets both times and can't wait for the next movie." Binger, I don't know if you know, Binger is the substitute for the N-word.
Yeah, okay.
Mad8 says, "Friday was fun, brother. Don't forget to get yourself some Crown XR on your next liquor run." Oh, hey, man. How's it going? I'll try and find some. I haven't seen it around. I bought a 21-year Bushmills yesterday. That I think I'll be having some tonight. Tonight, I think we're going to do. Tonight, I'll talk about my trip to Dallas. We'll do a whiskey review of the 21-year Bushmills, and we'll talk about some other stuff, some Canadian truckers, and all of the crazy antics that are going on with that, and who knows what else. Oh yes, we're definitely going to talk about the Maricopa judge who is sending memes, calling attorneys fat. Oh my gosh, it's great. It's my favorite story.
That'll be a fun show. I just took a look at some of those, and they're pretty over the top.
Did you saw the over the top one with the fat person like way up on the ladder or whatever? The best is like the interviewer from ABC News or whatever, like pretending not to find any of the memes funny while he's interviewing the person. Oh, God, it's great. Lancelot652 says, "Nick, I like to watch people when they don't know. That's called stalking, Nick." Look, what they don't know won't hurt them much. Oh, goodness gracious. Look at this. Look at this art house shot they have. One man. Or no, wait. Two men. One chin. In a battle of the ages. Will prosecutor Gary McCollum be able to bury Curtis Williams? They need to switch the focus on the prosecutor like a couple times. They need to do that. Oh my goodness. Two lawyers, one cup. No. Fish says Sword and Scale is a chameleon. He's anti-Second Amendment and anti-self-defense. He deleted his episodes prior to 56 where he berates this defendant and a homeowner who shot two home invaders who had broken into his home many times before. Look, that homeowner, I know exactly who you're talking about. The homeowner who shot the two people breaking into his home, I'm guessing you're talking about the one from Minnesota. That guy did everything
Hey, I'm live
wrong
right now.
in that situation.
Do you want to get her?
Everything wrong.
Chucha, go with Peaches.
Come in.
It's okay.
You know
I'm
what's
live
crazy
streaming right
is
now, painting.
He put out a
You want
bait.
to go with Peaches?
He
Go
put
with
out like
Peaches.
breadcrumbs
There's no
leading down to the
T words in
basement
here. Go.
for them to follow. He set
Go with
up
Peaches, please.
basically a
You
hunting
want to go with
line
Peaches? Go with
from
Peaches. Go with
the
Peaches. Go with Peaches. Bye, bye, bye.
Easy
Go to it.
chair, a
Go, Papas.
refrigerator, bottles of water, and recording equipment so he could record himself shooting them. Then after he shot them and they fell down the stairs into the basement, he executed them with a shot to the head. That's not going to look like self-defense or home defense to anyone.
I'll tell him you guys
And
all
he
said hi.
recorded himself saying,
Tulip loves coming in here because she knows I have snacks. And she just wants to find them because she's a little brat.
And
And she gives me those big puppy eyes. And I'm like, gosh damn it, Tulip, you're too
Would he have
cute.
been justified shooting them in certain circumstances? Yes. He, he, he set it up. He premeditated the killings that were going to occur. Like you don't get to do that. It's weird because they should not be breaking into your house, and you can be justified in shooting someone if they put you in danger. But you're not automatically in danger in Minnesota if someone breaks into your house. You still have to have reasonable fear of imminent death or bodily injury in your home. That guy basically set himself up to go to prison forever. It was a very bad choice. All of his choices, especially like the crazy mutterings he was doing while waiting. Those recordings, in my opinion, really sunk his case because he sounds horrifying on those recordings.
He shot him in the head after they were no longer a threat. I mean, he executed him.
Yeah, it's he did everything wrong in that case. He didn't make them break in. No, he did not make them break in. But what he did to set the breadcrumbs was he believed that someone would break in if he was gone. So he drove his car down the road and parked it in front of a police officer's house. I don't know why he chose a police officer, but he clearly had a reason to do that. Then he snuck back into his house through the back door, so presumably they would not see him do that. And then he set up shop downstairs with snacks, sitting in a chair in a position where they would specifically not know that he was there. So he's removed the element of the imminent danger aspect of it because he has intentionally set up a scenario where he would not be there, and they don't make any sort of threats towards him. You can't just shoot someone who breaks into your house in Minnesota. Maybe you should be able to, but you can't. He did a whole bunch of bad stuff there. As for Sword and Scale being a chameleon, maybe it's I don't know. Koi540 says, you often get requests for lawyer referrals. If someone made you a simple website
Not John Malin.
choose state, criminal, civil, etc., and directs you to lawyers, would it be useful? I want to support base lawyers that you know. We'll see. I'm working on something on the website front. I can't just have a auto referral system because there has to be like there is a theory that if I'm just directing people to different lawyers, that could be it's a weird thing. There has to be some sort of discernment or choice being made.
There needs to be a vetting process, or it's just pointless. And the vetting process is not obvious. I mean, I've struggled with this for years. I get these requests too. Unless I happen to know a lawyer personally and professionally, of course I can recommend that person. But unless I have that kind of relationship.
When the time comes, so I'll be sitting over there nearer to you. But for the moment, were all of you able to abide by my instructions during the recess? Nobody did any independent research.
Oh my God, we're going to do this every time?
Could you imagine if somebody said yeah?
All right, very good. Then in just a moment, I believe Mr. Michaels will begin his opening statement. You may.
It's like going to dog pose.
Statement, I would have request of the court, Your Honor, if you would please read the stipulation concerning the DNA evidence in this case and the cell phone case screen.
All right. And ladies and gentlemen, when lawyers agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts that you must accept as true are as follows. The state and the defense stipulate to the following facts. The iPhone belonging to Chad Olson, which was seized by law enforcement on January 13, 2014 from inside Theater Number 10, Cobb Theater at the Grove in Wesley Chapel, was tested by Mary Pacheco of the Florida Department of Law Enforcement biology unit for the presence of DNA material. The testimony of Mary Pacheco would establish the following results. 1. The DNA profile obtained from the iPhone black case, Exhibit AP13, demonstrated the presence of a mixture of at least 3 individuals. Due to the complexity of the mixture obtained from the iPhone black case, this data was not interpretable. Number 2, due to the limited nature of the DNA results obtained from the iPhone's black case screen, this data is insufficient for inclusion purposes, but may be suitable for exclusion. Number 3, due to the limited nature of the results obtained, Chad Olson can be neither included nor excluded as a contributor to the iPhone's black case screen. And number 4, Curtis Reeves is excluded as a source of the limited DNA results obtained from the iPhone's black case screen.
So that's clear as day.
By the way, absence of DNA is not evidence of anything, folks. You can touch an object and not leave DNA.
Why did I bring this up to start my opening statement? I brought this up
Well, I like this.
because I want to give it the context to look at the form of the information you're getting from the prosecutor right off the bat of opening statement.
Yeah.
What the prosecutor told you is simply not true. There is
Beautiful.
no stipulation, there is no evidence that the cell phone case or the cell phone case screen had the DNA of Chad Olson on it. It's just not true. Let's look at this. It says, as the court read, DNA profile from the iPhone case. This is an iPhone case, black case that has a white cell phone in a white iPhone. It's a case that has one of those screens.
When did they make a white iPhone? This hasn't
Finally,
been white
black and
iPhone.
white coming
They're
together.
talking about the outside. When they're talking about the screen, they're talking about the front of the screen where a person would kind of scroll on. And so what this says is that
Their iPhones are like gold, gray, or like blue now.
Due to the complexity of the mixture obtained from the iPhone black case, data was not interpreted. So based on what they got from the case, they couldn't interpret it. They had at least 3 people on it. So is it possible that if the evidence was properly preserved, that we would see Mr. Reeves' DNA, Curtis Reeves' DNA on that case as it hit him in the head?
It is bizarre that Chad Olson's DNA was not detectable on his own cell phone. I mean, it should be all over that cell phone. I don't mean in a gross way, folks. Just
The sheriff's office didn't go in there and try to preserve for any DNA evidence. They had a tech pick it up, manipulate the phone. Later on, they pull it out of a room again and try to turn it on to see whose it was, even though we knew it belonged. Due to the limited nature of DNA results obtained from the iPhone's black case screen in front of it, this data is insufficient for inclusion purposes. It may be suitable for exclusion. Again, that doesn't tell you that Chad Olson's DNA was on the phone. It tells you they can't tell you whose DNA was on the phone. Next page, please. Due to the limited nature of results obtained,
nice to see the comments are as classy as ever.
Included or excluded as contributor to the black case screen. So what they're telling you is, not as the prosecutor told you, the evidence will show with the stipulation that, not true. That phone does not come back with Chad Olson's DNA. You know it's his phone. His wife said, that's my husband's phone. The prosecutor and the state attorney's office and the sheriff's office, they all went in there. We know it's Chad Olson's phone. But there's no DNA evidence that says his DNA was on it. So
The reason he's pointing this out
is excluded as a source.
is because the argument is that Curtis Reeves' DNA wasn't on the phone, therefore the phone didn't hit him.
Two sides to it, the corners to it, the screen, it's Mr. Reeves. Maybe. And if the back is Mr. Reeves, then certainly this isn't something that would be unusual. Not unusual. And so I bring this up to you because I think that it's important.
Nobody destroyed evidence or anything like that. It's just DNA is not always detectable, and when it is detectable, it's not always discernible.
That you realize what it is you're being told here. From off the bat, you're told there's DNA on the phone. Another thing you're told, you're going to see photos of it this morning. He's all the way in the other row. Chad Olson is a whole row away from Mr. Reeves.
There it is.
Yeah.
Chad Olson is a whole seat over from Mr. Reeves. You can see how very close they were. The theme of the prosecutor's case is that this was over public. And what the prosecutor told you going in is, well, all I have to
A
prove
court reporter should give the judge the number
Is-
for a hairstylist.
that
Mhm.
someone was shot, somebody died.
You got a little wave going on.
Their state of mind regarding it. That's not true. What the prosecutor has to prove, what the government has to prove, what the state of Florida has to prove in this case, beyond a reasonable doubt, that this was not justifiable. And when they talk about justifiable, the prosecutor told you, frankly, that's the law of circumstances. Under the same circumstances as Curtis Reeves, knowing what he knew, you would decide if it's reasonable if you were trained like Curtis was. You would decide if it's reasonable if you're 71 years old. And although the prosecutor's telling you he walked all right, he did all this and that, you're going to hear from experts. I'm going to talk to you a little bit more about that, about what the realities of the aging process and what the realities of Curtis Reeves' condition was. So the framework of what you're to decide, the states that I'm going to ask you to come back to, I can't ask you how to decide a case. You're the jury. You look at the evidence, and that evidence has to measure up beyond the exclusion of every reasonable doubt that Curtis Reeves did not act justifiably in protecting himself and protecting his wife who's sitting next to him. So since we're talking about Curtis Reeves and stepping into his shoes, let's think about that for a second.
Mhm.
Number one, he's in the theater. The prosecutors tried to make it seem, the same way they tried to make it seem about the DNA, that this theater is somehow lighted so you can see everything. A lighted movie theater with the previews on. Imagine. They're telling you, don't believe. If somebody comes up with a description in one word, don't believe. No one can tell you what to believe and what not to believe. Their job is to put on the evidence. You believe or don't believe. You're convinced by their evidence. Not because they're putting parameters on you, they're giving you rules. Don't believe this. If you hear one word, that's not true. Listen to the testimony, which you will. Let's talk about Mr. Reeves. All right. 27-year police veteran. Served his community for 27 years at the Tampa Police Department. Highly decorated officer. None more decorated in his years there. They thought so highly of him that at one point, the powers that be with the Tampa Police Department came to Curtis Reeves and said, we want you to start a SWAT unit, which he did. The responsibility took very seriously, because that responsibility, that is a responsibility with other people's lives, his men's lives. And so he became trained, and he trained his men. He trained his men so that every day they could come home to their family, they could go home to their family and be safe. That's the training of the man that was in the theater with his wife.
I'm surprised they didn't have a heart attack.
He was a superstar. And when he was there, he did everything from patrol as a young man to homicide detective and everything in between. So he saw what it was like out there. He knows about danger. He knows what a fist can do to somebody as a young person or an old person. And by the way, the state's telling you, well, it's preventing great bodily harm. You're going to get a definition of that. That means something more than a bruise. It's not a bruise. That's what the judge is.
It's a little bit farther than that, I would think.
After 27 years, the Tampa Police Department.
Well, also, it doesn't have to actually have happened. It has to be the imminent threat of that harm.
He retires from the police department.
You don't need to have something to scratch to be justified in acting in self-defense. Even deadly force self-defense.
Now he's kind of in a job where he's dealing with the entertainment industry, the pleasure of the experience in the park industry, and he receives training for that. You're going to see, we're going to talk about it a little bit, some of the various courses he's doing. You're going to see a list of courses, and we'll talk about some of them.
How popcorn can kill. Fists of legend.
So, throughout his years,
Tall men and the dangers of tall men.
he certainly learned how to assess risk. He certainly knows how to spot danger. And so when he's in that theater, it's no different. That's training and experience. That's something that you must consider before you make a decision, whether it was reasonable or not.
What movie were they at? It was the premiere of
It is
Gone with the Wind. That's how long it's taken to travel.
And you're going to see that
It was a Chaplin movie.
tries to paint this picture. They say Mr. Reeves trying to paint the picture. By the way, he's a law officer. He should have known better. When he got arrested, he talked to them and he knew the words to use. Well, if he's a law enforcement officer, he also knows he has a Fifth Amendment right not to speak to the police. And he can remain silent and call his lawyer right away.
Well, he called you pretty quick. you were his lawyer. The other defense lawyer was his lawyer the next day.
You're going to see there was an attack before the popcorn was sent. I'm going to show it to you. It wasn't just one attack, and it wasn't just popcorn being thrown. But yourself and Mr. Reeves' scene. This is kind of a very unique situation in criminal law, because as jurors, you have to kind of put yourself in his shoes.
But see, notice what he's doing. He's doing what we were talking about before.
His body starts to break down.
They're misrepresenting all of this to you.
Continuing to break down, and he retired. Just couldn't do the job.
You can't trust them. They're big, fat, lying liars.
And so he's off to retirement with his wife. Back in 2014, they were married for 47 years. His wife, Vivian. They have 2 children, which you're going to hear from. Matthew, who is a police officer with Tampa, following his father's footsteps. Jennifer Shaw, she's the daughter of Curtis and Vivian Reeves, and she has
She called Jennifer Shaw. Huh? She was getting divorced at the time of the self-defense immunity hearing.
Big house. They're hoping for a lot of grandchildren. We want to have room to entertain. And they decide to go to a movie on January 13th, 2014. As you know, those
2014? What?
as he walks in, let's think.
That's how long ago this case was? Jesus.
Prosecutors say, well, he walked. He's 130 yards of football in the third away, football field in the third. I guess not counting the end zones. Football field in a third away, and he walks there just fine. Doesn't use a cane, doesn't use a walker. You're going to hear from several witnesses. They're going to tell you about his physical condition. You're going to hear from Matthew, his son. Matthew's going to tell you about his father, a robust, vigorous man, as he sees them over the years being able to do less and less. Can't leather work, can't do woodworking, has trouble with his hands. They went on a hunting trip right before the movie, and Curtis Reeves couldn't pull back the compound bow. They were looking to getting him across.
Can't leather work, can't woodwork. Am I getting old?
Over the years. He knows that his father calls him up, Matt, I need the leaves taken off of the patio, screen with the back. Jennifer, his daughter, is likewise going to testify how she's seen her father over the years deteriorate. She's seen him at one point, again, outdoors, going hunting, fishing, camping, to a point where he can't take apart the paddles for a kayak. To the point where when he's on the floor playing with her daughter, with his granddaughter, he can't get up without help. Vivian Reeves
Ugh, it's going to be terrible when I have to watch like that happen to my dad. It was really weird. A few years ago, me and my dad went to Disneyland, and he got sick after riding one of the roller coasters, and it was the most bizarre thing. I'd never seen my dad get sick after a roller coaster before. He was like my roller coaster buddy growing up.
At any rate, she's going to tell you how she's seen the changes in her husband as well. How he needs to push himself off of the chair to get up when they're watching television. A little thing, some of us. Very important in this case. In fact, she's going to tell you that the day they were in the movie theater, the shoes that he was wearing, that Curtis Reeves was wearing, you didn't have to tie him with your hands because he had problems tying his own shoes.
Aww.
The thing you do, like you put on a preschool, so they can tie them up. You're going to hear from Dr. Donna Cohen. She's a PhD. She's a leading authority in the field of aging and the process of aging. She headed up the aging studies at the University of South Florida. In fact, she started it. She's been doing it for over 50 years. She's an educator. She's going to testify as an expert. She's going to testify as an expert in the field of aging, the process of aging, and how it affects one's vulnerability.
I hope she's young. It would be funnier.
Because we can all think, well, he's walking all right. Really, what's going on in this thing?
This poor old man. I mean, take it, he did kill a guy, but
Realization of vulnerability. It's important.
yeah.
Take notes, Nick.
We take for granted about getting older. She's going to
I know
tell
all
you
about it. Oh my
scientifically,
God.
as an educator, how that works and why that works. You're going to hear from Dr. Michael Foley. He's a radiologist, a preeminent, nationally known radiologist. Why? Because the prosecutor's telling you, look at him, he can walk. You're going to see his x-rays and his MRI. That radiologist is going to tell you about all the degenerative processes, the breaking down of his body that you can see on the x-ray.
This poor old man. Could you imagine having to sit there and listen to how old you are?
Not so good on the inside. He's got problems with his neck, his back, his shoulders, his hands, his hips, osteoporosis in his hips, all the way down. And so what does that do to an individual? Makes them more vulnerable. Also, it makes them more vulnerable to serious injury. So in that regard, you're going to hear from Dr. Bernard Adams. He's a pathologist. He used to be the medical examiner for Hillsborough County for 20 years. And now he's a
This is
pathologist.
going to be a long trial.
He's going to testify. The interesting thing about Dr. Adams is
A lot of early
he's going to
morning.
show you on a model the most vulnerable
Ooh,
part.
what's the model's name?
The most vulnerable part of the human body is there. So he's going to show you why it's vulnerable. He's going to tell you about older people. As you age, your brain shrinks, leaves more room in the skull, which makes you more prone to injury if you get a blow in the head.
Old people are dumb confirmed.
He's going to show you the changes in the bone structure of the neck, of the rib cage, and again, make an older person as they age, more vulnerable to serious bodily injury, to great bodily
The
harm.
jury's going to feel themselves getting more age frail as this trial proceeds.
The anatomy of how when you close your hand, it forms these points, knuckles, and that becomes a dangerous weapon. You heard a little bit about what Curtis Reeves said he got hit. He did. He has a red mark on his arm. The prosecutors tell you somehow magically the phone flew around, this and that. Well, if it was so well lighted, you can see it on the video, why didn't everybody else see that pattern? Why didn't everybody else see the popcorn round? Because it was a dark theater. And the video, by the way, since I'm here, we're going to talk a little bit about the video. That system is not very good. It captures, it's infrared, it's motion detecting of a sort. So you're not going to see a clear video. In fact, our expert, Bruce Coney, who again is a nationally renowned expert, he worked on the Monica Lewinsky case. We actually had him look over the JFK tapes again. He worked for the FBI, headed up their audio and visual department. He's still out there testifying as an expert. He will tell you about the resolution, how bad it is. I don't have it in front of me, so I don't want to give you the wrong numbers, but the numbers compared to what the iPhone was. The iPhone had like 600 pixels, and this had like
600 pixels.
12,000. So you're going to see, you get a little piece of it today, a video that doesn't.
I'm not going to misrepresent the numbers. It immediately misrepresents the numbers.
Let's talk about the facts of the case.
Oh, please have a fax the case.
Mr. and Mrs. Reed.
Stop telling me about this 18-week trial you're planning.
61.
I'm going to go to Texas for a week, come back. This thing's still going to be going on.
To watch a movie, to get the experience of a movie, to immerse yourself in the movie, to sit in your seats, a comfortable seat, have quiet around you, and be able to enjoy the experience of watching a movie in a movie theater.
With your $100 popcorn.
The plan is to meet their son Matthew, the Tampa Police Department police officer. He's washing his truck, so he's a little late. He's
Yeah, isn't it a felony larceny to
walk in.
steal someone's popcorn these days?
The prosecutor told you it's true. It's true. He paid for his ticket. He walked in. They got a cold drink and a popcorn, which they share. Miss Vivian Reeves brings a little plastic baggie. Curtis Reeves gives her half the popcorn so they can each have their own. And they walk into the theater.
How cute old
They
people.
walk to the theater. Mrs. Reeves goes to.
By the way, the theater was posted, no guns.
That's true. It is the theater.
But under Florida law, that's not a criminal act to disregard that sign. At worst, you're committing a civil trespass.
Their son,
Usually only after notice, right?
mom, and dad have two
You know,
sons, one on either side.
I mean,
So they
if this
walk
was a law school class, I'd say you're actually committing the trespass
very back.
inherently because you're there contrary to the conditions for being there. You're not there by license anymore. But nothing ever happens until you're notified. It's a practical matter.
Wall, it's about
Right.
5 feet.
They always ask you to leave first.
Prosecutor told you
That's the
about that.
first step.
Interesting fact about that wall is the chairs in the theater.
So you don't end up getting trespassed until you've gotten the notice. This is a practical matter.
Can't lay down, but they reply back. With that wall behind the scene, you're not going to get as much movement on it. So Mr. Reeves sat there. Curtis Reeves, his wife, directly in front of Curtis Reeves. Already there is Nicole Olson.
So he chose the seat because the seat
Reeves is chatters.
reclined it all, so it's easier for him to get up because he's old. He's conscious of his oldness, is what he just told the jury.
They sit down to enjoy the movie. Curtis Reeves notices the phone is on. He's not talking, but there's a white light. There's a white light coming from the phone. We know he was on the phone. We know he was on Facebook. It doesn't matter if he was talking or not. There's a white light coming from the phone, and it's in Curtis Reeves' face. He asks him politely, would you please put the phone away? The answer he gets is, I was texting my effing daughter, be you mine? Something to that effect. Yeah, put yourself in the theater.
All right, I am done. What do you guys think of this one?
There to have a movie experience. Ask somebody to put their phone away, and the response is, bug off, it's none of your business, it's F off.
By the way, Olson's wife did sue the theater in part because they did not adequately enforce their no-gun policy.
Finally, Mr. Reeves
Did
does.
she win?
I don't know. I have to check.
Let me edit this video.
He's going to tell the manager. At this point, there is no thought that this person's going to turn into some hostile force. It happens later. At this point, it's just allowed.
Is she wearing makeup? This is a man.
And ruining everybody's movie experience, including.
Oh, you know what? I forgot one thing. They have a little
George,
circle.
you were there?
Curtis Reeves walks down the aisle. Some people are saying he mumbled. They'll tell you, I don't know if he was telling his wife, I'll be right back. They don't know what he was saying. Some people don't hear the mumbling. Certainly, he didn't kick anybody. He didn't hit anybody. You'll see the video for yourself. In fact, when I finish, I'm going to show you that part of the video. You hear from the prosecutor how he can just walk down the aisle. It's not a problem. It's really close. Watch the video.
Better.
This is what you're going to see.
Yeah, a little freckle right there.
Curtis Reeves walks down the aisle. He has his hand up. He's touching the wall for balance. You'll see him do it. He goes out to the desk, the service desk. The manager's there, a fellow named Thomas Peck. He's talking to this woman, Dawn Michelle Simpson. If the prosecutor doesn't call her, we will. She's there talking to the manager, telling him that she wants some movie posters to decorate her house or a TV or some sort of thing. Mr. Reeves just waits. He doesn't interrupt her. He's not rude, and that's the testimony you hear. You hear the testimony from Dawn Michelle Simpson. You hear the testimony from Thomas Peck. That Mr. Reeves was polite and acted very nicely. Please.
The theater employee was also sued by the wife.
Those aren't the
I
words.
wonder if that might affect their testimony.
Mr. Reeves walks back into the theater. And I understand what the prosecutor's saying. The prosecutor's saying, well, he says in his statement that he initiated contact.
Amazing to think that those lawsuits could have been resolved and gone to the Supreme Court by now.
Who at this point is a suspect in committing a crime, not because it's a whodunit, it's a prosecutor rightfully said. It should have been because the detective should have been thinking, was this a justifiable use of force? Never entered his mind. So they have Curtis Reeves sitting there, and they don't ask him these questions. They don't go back and re-interview him. So it's all right for witnesses that are going to be pro-government or say something that the state wants them to say, and you to believe them.
I'll sustain it.
The evidence will show that the state will present some witnesses that say things that's favorable to their side of the The evidence will show, and
Brilliantly reframed it.
as I just heard the opening statement of the prosecutor, that the prosecutor's argument is going to be that Mr. Reeves just made this statement during his interview, his voluntary interview. So you're supposed to believe one, that's what they're telling you, and then somehow not question the other, think maybe there should be more details to the other. Maybe the detective should have gotten back to Mr. Reeves and spoke to him. He was willing to do it. So what happens when Mr. Reeves gets back in, as he's coming to his seat, Chad Olson turns around and says, I see you turned me in. Words to that effect. Mr. Reeves at this point, seeing that Chad Olson put his phone away, leaned forward and told him, I'm sorry, if I knew you put your phone away, I wouldn't have gone to the manager. You're going to hear from Nicole Olson. She's going to tell you that from the first time Mr. Reeves asked Chad Olson to put his phone away, they took it as a bossy way to ask. Why is that important? That's important because Chad Olson gets annoyed. He was annoyed. That's what you're going to hear.
Avoid the noise, y'all.
Annoyed. When Curtis Reeves asked him,
Hey, what's good for the goose is good for the gander. If the prosecution's going to say, hey, you should infer that the defendant was annoyed and acted out of anger, the defense can argue Chad Olson was annoyed and he was acting out of anger. Maybe a little juice from his trip to the bar before the theater.
All right, exporting now. I'll let you guys watch the one that I did yesterday. So if you guys want to volunteer for the eye project, that would be awesome. Still looking for volunteers. Would love to have you guys send me photos of your eyes so I can paint them for you.
She's going to tell you she saw him leave. The deputy's going to tell you that too. You're also going to hear from Joanna Turner. Again, if the state doesn't call her, we will. She's going to tell you she sees a throwing motion. And I'm going to show you this morning that part of the video. So you can see that there's a throwing motion. There's a throwing motion, and then about 10 seconds later, this is still going on. Nicole Olson is trying to hold her husband back. I mean, think about this. You're going to see Nicole Olson. Her left hand was on Chad Olson's chest.
Don't you want your eye painted like that?
Hers or not, you'll be able to see it. The evidence will show that her arms are short. So we can only imagine that Chad Olson had to be on top of her. Right?
Ooh, on top of her.
Coming over towards Curtis Reeves. Again, I'm going to show you some video this morning. You're going to see that. So this isn't about public. And how do we know that? We know that because we're going to present a use of force expert, Roy Bedard, an expert that testified for the state. In fact, this very office not too long ago, this prosecutor's office. And he's going to tell you that it's impossible.
What time lapse has gotten the most views? I'm not sure.
Curtis Reeves discharges firearm in response to pop.
You'd have to like go
The
through
times
and
just don't add up. It happens so quickly that nobody humanly possible.
I think they only get like 400 views at most. Like, see, this one's got 468.
That's what I said.
Oh, this one's
before
got
the whole thing.
575.
Prosecutor told you, well, you're going to hear that somebody said throw popcorn at me later.
It usually, oh, this one has 585. It usually depends on when I post them. And like if I post them on like both of my Instagrams and what time and whatnot.
So who knows if this is?
I don't know. The algorithm on Instagram is really fucking weird.
The prosecutor's right. They had over Pasco County Sheriff's Office had over.
So Roy Bedard, the use of force expert, was the state's expert.
Everything.
In the,
Here is
Michael
my
Dreyfus trial. That's
art
the
Instagram.
trial.
They had officers from departments I frankly had never heard of. They were all there.
This is just taking forever to upload.
That they were all there, but
My internet sucks, as you guys know.
The witness statements. Witness statements are essentially the police go there and they say, "Here, I'm going to give you a witness statement. Write down. Tell me what happened." Something to that effect. Very general. What they're supposed to do is, if two people are together, they say, "Okay, I want you to separate. You go over here, you go over there, because I don't want the witness statements contaminated." Officer after officer will get up there.
Thank you, Jeremy7 Alpha, for the super sticker, and it's 100. Thank you. That's Star Wars girl going to Chick-fil-A later. That does sound great.
So you have 90 police officers, 70, 50, whatever the number is.
I doubt it. I do need to go to the post office. I could always pick up Peach's lunch. That's a good idea. I'll pick up Peach's lunch.
Two of the forms that were filled out by a couple were the exact same. The wife filled them out for both of them.
You gotta abuse the tags. I have a bunch of tags. I just don't know which ones work. It's really frustrating.
Is that something that you can really believe?
He told the jury he wasn't going to do that. Needs to be very careful. Tell the jury I'm not going to tell you what to believe, and then you start telling them what to believe, you start to lose your trust.
So Mr. Reeves turns after speaking to the manager. Things happen really fast. We'll also tell you.
It's loading.
It happened fast. I'm not sure if I was standing up.
Oh, yay. It's done. Okay. You guys see all of my beautiful rows?
That's happening fast.
And then it gets all messed up. We're going to be one step closer to getting it fixed again. All right. Here we go. Yay, look at this new one. All right, let's play this time lapse of everything that I painted.
Nicole describes her husband in his words as agitated, as mad, as angry. Mad. Other people in the theater will say the same thing. In fact, today I think you're probably going to hear from
abused
Angela.
Puppies of Instagram, Cats of Instagram.
Angela.
Yeah. I guess I can look into better tags and stuff.
And you're going to hear from her that
I was thinking of even like promoting them, like you pay money to promote it, but at the same time, I'm like, people will find it when they find it.
I thought, from what I heard, I only heard one of them. From what I heard, I thought a fight was going to happen. He said he only heard from one of them. Nicole Olson will tell you that her husband was the louder of the two. She was right there.
Okay, you can see the texture of the canvas. What do you guys think?
Guess what? Curtis Reeves has the right to carry that gun. In fact, under the Law Enforcement Officer Safety Act, enacted by the United States Congress.
So you're only happy 1/3 of the times. No, I'm happy every time I upload, but I mean like when I scroll down and I see that, it irritates me.
You might not remember some
Google says it's because of more.
Guess what? That bad guy remembers.
Encourages a strong word.
We need channel membership emojis. There should be. Are there not? I thought I. Oh, you know what? I needed a certain amount of channel members before I can upload emojis and stuff. What kind of emojis do you want?
So he had a right to carry a gun. He was encouraged by law to carry that gun, Curtis Reeves was. After the shooting, what did Curtis Reeves do? Took the gun.
Pet eyes is a good idea. Yeah, that's what I was thinking of doing next. Like, I don't care what animal you have. Like, if you have a pet, send me a picture of your pet's eye, and I can try to paint it. But that would be when I'm done with the eye project. I think that would be really fun. And I could get, like, a bunch of round canvases.
Please come in, handcuff him, take him out.
I think more people would volunteer for that, too.
These sort of calls come out to law enforcement.
The channel icon would be a good emoji. Oh, like my little person. I need to find that. I don't know where I made that one day, and I don't know what happened to the file.
Move over, his son comes, gets his wife, and takes her out of there, and she is in
I have a Siamese. Are you the person that sent me your cat's eye and said, my cat wants you to paint it, please? I got a couple people that sent me their pet's eyes, but I remember somebody specifically saying, my cat wants you to paint their eye. And I was like, I might give in. How about a side profile of the pet? So I paint like a little section like eyes just because it is a subject matter, but it's also, it's like a study, right? If I just painted like side profile views, that would be a very long time. Yeah. Let's see, but we got 84 likes. If you guys haven't smashed the like button, please do so we can get up to 100 likes. That'd be awesome of you.
Here's something else. There's a video. We all know. We talked about the video.
How many times have we painted Tulip? I haven't painted Tulip. I've sketched her, but I haven't painted my little bitty puppy princess. I couldn't capture her cuteness. She's so little. Me and Peaches talk all the time about how we want to paint a like a mural on our ceiling of her, like instead of little cherubs, it's little tulips. You see, this shit pisses me off. These stupid spammers. If you guys are ever on Instagram, go report this shit because it pisses me off. But yeah, so we can scroll through my little timeline. Look at the different eyes.
What happens to that video?
Crazy, huh? How eyes can just be so different. And then other stuff.
When the Pasco County Sheriff's Office finally realizes that this is probably something they should have a look at.
Crazy, 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 huh?
Days later, they go to where? Corporate?
Same subject matter, but all the different renditions you guys can get. I like it. I dig it. I love doing these. I have fun. And then I add them onto like this little story highlight because I know once I'm done with this, I'll be moving on. But you guys can see. I try to be fun with my stories. This one's a lot of fun because I haven't posted any of the Queen of Hearts stuff. So I have this whole like story if you want to go through and watch like my entire process of painting the Queen of Hearts. And, you know, that whole time lapse and stuff. There's a lot of fun stuff on here. Let me just scroll through. It just takes forever to load. But yeah, there's some fun stuff. If you guys don't know, this is my regular Instagram. I've been posting my cosplays on here if you guys don't know about that. So I have I obviously have different photos from each pose. Or from each costume. And so I don't think I posted this anywhere else. I'm going to post another character on here today because it's Valentine's Day. But so here's like different poses of me in the different cosplay costumes. And so, like this one, I had to throw in the Rogue image because people were giving me shit. They're like, why did you need to do an ass shot? I'm like, because that's what Rogue is like known for. But so, I'm gonna be posting all of my my cosplays in rows of 3, of course. So you'll have 3 different, not for all of them, but you'll have different poses. Like the Lois Lane one, I figured out how to do one of those like splits where it's like, because one of the poses she's like laying down on the cardboard, and so it's one of those things where it's like a cross. Yeah. But so yeah, I have this. Hey, I passed 27K fucking finally. I was at 26.9 forever. So thank you guys. But yeah, follow me on my Instagrams. That'd be awesome. Thanks for subscribing. We're only 10 likes away from 100. That'd be awesome. Once this stream is over, if you guys could please leave me a comment, I would really appreciate that. I'm going to pause this stream. Yeah, leave me a comment. Let me know what you thought, if you liked this stream. And yeah, can't wait for the calendar. I'm so excited for you to get them. They are, since they got the binding in, they're punching the holes into it, and they're putting all the binding together. So they started assembling them on Friday, and they're closed on the weekend. So they're finishing assembling today. And I believe he said that it takes 5 to 7 days. I think I'm right about that. I could be wrong, but he said they're getting a lot of people like calling in sick and stuff, which sucks. But they should be done by this week. Fingers fucking crossed. And they should ship them to me, and I should get them hopefully sometimes next week, or possibly the week after, which I will not be happy about if it's the week after. But the second I get them, I'm going to start shipping them out. When do you start the next calendar? I'm actually going to start taking photos in March. I already talked to my photographer. I'm going to start off by taking pictures of Samus, and then Handmaiden. And I just need to get lightsabers for Revan. And then I basically have Revan's costume. And of course I have to film all of that, which I don't enjoy doing. It's such a long process, the editing for these damn videos. And I haven't even finished filming the ones that I already did in the calendar. But yeah. But anyways, guys, thank you so much for being here. I hope you guys all have a great Valentine's Day. I had a video come up on my main channel at 8, which was my reaction to the Lord of the Rings trailer. And then I have another reaction to the, whatchamacallit, the Doctor Strange trailer that's going to come out at 10 a.m. And then I'm going to spend the rest of the day with Peaches, and I will see you guys all, I guess on, what day is it? Monday? I'll see you guys all on Tuesday. But everyone, thank you so much for being here. Thank you so much for watching. I hope you guys all have a great rest of your day, morning, evening, afternoon, wherever you are in the world. And may the force be with you, because we are really, really, really going to need it. Bye, everyone.